Welcome, everyone. I'm reporting live from Pleasant Lake, Maine, and it's a pleasant day. We're going to do Florida evidence and Florida criminal procedure. We just had Amy dissect a question in thorough detail, and I thought it was really instructive to see how someone can analyze so much from a singular question. I'm going to take a different approach and give you all exposure to a lot of questions from different sources. So we'll start, I think, with Florida evidence. So without any further ado, I'm going to share my screen and everyone could see my screen, right? Thank you, Grace. Okay, let's just jump into some evidence questions. And we're not going to do polling because I want to get through a lot of questions today. Hey, maybe we'll get through 1,000,000, maybe not, but let's just put them in the chat, say it out loud. We'll start with the first one. Which of the following hearsay exceptions requires the unavailability of the witness under the Florida evidence rules? Excited utterance, present sense impression, statements made for purpose of medical diagnosis or treatment, or statements made against pecuniary interest?
Statements made against pecuniary interest.
Yes, sir. Statements against interest require unavailability. Statements that are admissions by a party opponent, it doesn't require unavailability. Unavailability is essential for statements made against interest. We agree with that?
Yes.
All right. Statements made against interest. On the Florida evidence rules, the hearsay exception for statements made against pecuniary or proprietary interest are often referred to as declaration against interest, generally requires the declarant to be unavailable. This exception applies when a person makes a statement that is against their own financial interest, proprietary interest, or that tends to subject them to civil or criminal liability or render invalid a claim against them against another. The theory behind this exception is that people do not usually make statements that are against their own interests unless those statements are true. However, because the declarant is not available for cross-examination, courts require the declarant to be unavailable before these statements can be admitted under this exception. Can anyone give me a few examples of when someone would be unavailable?
Refusing to testify.
All right, Temas, what else?
When they're very sick in the hospital.
All right, what else?
Can't
Dead.
be located.
Dead, can't be located, can't remember the pertinent information. Just because they're hostile, just because someone's hostile doesn't mean they're unavailable. Unavailable has to mean that they aren't there or their mind doesn't work. If they're there and they're hostile, or they're just, like you said, pleading the fifth, that doesn't make them unavailable. Okay. And by the way, if you want to be mad at someone that every word starts with the capitalized letter, you can be mad at someone with 2 thumbs. This guy, it was just the software I use for these Florida evidence questions are written like this. I don't love it either, so just get mad at me. All right, a plaintiff alleges that he suffered an injury when a ladder collapsed under him at a construction site managed by the defendant company. In its defense, the company attempts to present testimony detailing its regular safety procedures for inspecting and maintaining ladders on the site in order to inform the jury of the question of negligence. Under the Florida Evidence Code, the evidence is irrelevant. The evidence is admissible only if it's supported by a written safety policy or procedure. The evidence is admissible if it reflects the routine practices of the company. The evidence is admissible only if there's a universally accepted safety standard in the construction industry. Let's see. I got people in the chat saying, someone saying C. Anyone else agree with C? CB A? ABC? Yep, some more agreements with C. Yeah, routine. Hey, my friend Matt Beckerman, he said the difference between routine and habit. Does anyone remember what he said? A little bit of hearsay, he said, she said.
It's
I think-
specific.
Go ahead, Taylor. What do you think, Taylor?
I was going to say, I think with habit, he said it's specific and regular. And it
And-
has to, does it have to be corroborated?
What's the difference between habit and routine is my specific question.
I'm not sure.
Anyone else? I'm the only one who listened to Matt's lecture.
I think he said the difference was a habit is for just a singular person versus routine, which is for like a company.
Yes, that's what he said. I don't know if that's 100% true, but at least, I mean, you know, there's words. We speak English, you know, a word can mean a lot of different things, right? Like, what's the word? Oh, I've seen this word do the greatest transformation in history. Goat. Back in my day, calling someone a goat meant they were like the scapegoat. It was their problem. Now calling them the goat means they're the greatest of all time. Like words can mean different things. So like, I'm not sure if that's the black letter definition, but if Matt says that's the way it is, I'd accept that that's a generally accepted thought. And it's just good to think about. Routine is,
Gives you a starting point. You want to lay down or do you want to go?
sorry, Suzanne, I'm going to have you.
I'm
on
sorry.
mute. No worries. So routine is going to be, if it's a business where habit is going to be individual, right? Okay. Next one. In a lawsuit for breach of contract, Johnson is suing Green for damages. Johnson's attorney believes certain parts of Green's deposition would strongly support his case, so he plans to read excerpts from the deposition at trial rather than call Green to the stand. Green contests Johnson's use of deposition in court. How is the court likely to rule? Johnson may use the deposition at trial, but if requested, he must read all parts that in fairness should be considered alongside the part introduced. Johnson may use the deposition at trial, but only to contradict or impeach Green's prior inconsistent statements or pleadings. Johnson may not use the deposition at trial as Green is available to testify and there are no exceptional circumstances. Johnson may not use a deposition at trial as this would make Green his witness and prevent impeachment. Let's see. Grace saying A. Anyone agree, disagree with A? This one's very similar to a question on the FBBE model questions. And like I always tell people, these FBBE questions are the ones to review the most. So I agree. Johnson may use a deposition at trial, but if requested, he must read all parts that in fairness should be considered alongside the part introduced. In Florida, a party is allowed to use a deposition at trial under certain circumstances, even if the deponent is available to testify. Furthermore, under the doctrine of completeness, if a party introduces part of the deposition, the opposing party can require them to introduce any other part that in fairness ought to be considered with that part introduced. Therefore, the court is likely to rule that Johnson may use the deposition at trial, but if Green requests, Johnson must read all parts that in fairness should be considered alongside the part introduced. People always say, what are the questions like on the Florida bar? This is a very similar one. This is modeled after an FBBE question. I've taken the Florida multiple choice. My tutors all have. They're very similar to that. Okay. Let's learn about Miles and Davis. Miles and Davis were involved in a boating accident on Florida Lake. Prior to any lawsuit being filed, Miles told Davis that he was speeding at the time of the accident and offered to settle a claim for $1,000. Davis declined the offer. Subsequently, Miles sued Davis for damages relating to his personal injuries and personal damage, while Davis, who was not injured, counterclaimed for the damage to his boat. At trial, Davis's attorney called him to the stand and asked if Miles ever admitted fault for the accident or made any offers to settle the dispute. Miles' attorney objects to this line of questioning. What should be the trial court's proper ruling? Sustain the objection because offers to compromise a claim are inadmissible to prove liability. Overrule the objection because the admission of fault was made prior to the filing of a lawsuit. Overrule the objection because only an offer to pay medical expenses is inadmissible in the Florida Evidence Code. Overrule the objection because Miles' admission of speeding is a confession of guilt. All right, Henry and Pablo are saying A. I agree, right? Offers to compromise a claim are inadmissible to prove liability. Sustain the objection because offers to compromise a claim are inadmissible to prove liability. The Florida Evidence Code, similar to the federal rules of evidence, prohibits the use of offers to settle or actual settlements to prove the validity or value of a disputed claim. The rule encourages parties to negotiate and settle disputes without the fear that their offers will be used against them in court as admission of guilt. In this scenario, Miles' admission of speeding and his offer to settle the claim for $1,000 are considered an offer to compromise. Hence, it would not be admissible as evidence of the liability for the boating accident. Consequently, the court should abstain the objection. This is a very important question because they love to test this and it's different from federal law. And again, can't stress enough, if you're taking both, you have to have a procedure in place to focus on memorizing the distinctions of Florida, flushing them out, and focusing on only federal law the very next day. If you're only taking Florida, that's a blessing. If you're taking both, that is one of the most difficult things to do because the bar examiners do not care. They're not going to be like, oh, well, they took Florida, so let's give them a point on this one. Like, no, they're just going to grade the Scantron. So you should have, we have distinction lists in the classroom, and you should have a procedure in place. I wouldn't so much focus on the dates and such today. I would really focus on that in the days leading up and really have a procedure to keep that sharp, because that could be the difference maker between a few questions. Now, here's a common distinction between Florida and federal. Which of the following is not a privilege recognized in Florida in a civil case? Attorney-client privilege, spousal testimonial privilege, sexual assault counselor victim privilege, or clergy penitent privilege?
I think
Every-
it's B.
Yeah, everyone's ringing up the B, right? Key distinction, they do recognize spousal testimonial privilege in federal law. In Florida, we recognize the spousal communications privilege, pillow talk, right? That was really weird, the student who just joined the room, because that was something I heard a rapper name. But yeah, in Florida, we do recognize the spousal communications privilege, which will survive even marriage. However, in Florida, we do not recognize a spousal testimonial privilege, which means I cannot refuse to testify against my wife under a privilege. Excellent. It's generally not recognized in civil cases in Florida, although the confidential communications privilege is recognized. Does anyone have any questions about that distinction? Spousal communications, pillow talk, things that are told, that's not an official term. It's an actual.
Yeah, Andrew, I have a quick question about it actually.
Go ahead.
So I was reading last night, and I may have gotten a little tripped up, but like can a spouse prevent another spouse from testifying under this privilege?
Well, first and foremost, absolutely not in Florida, because Florida does not recognize this privilege. But in federal law, that is a good question. In federal law, the answer again is no. The way that privilege works is it's a privilege that the spouse can invoke, not a privilege that the spouse can cast upon the other. I cannot prevent my wife or husband or non-binary partner from testifying against me, right? If me and Sally were married for 30 years, Sally hates my guts and she wants to see me rot, I can't stop her from testifying against me. Now, if me and Sally have been married for 30 years and she loves me and she doesn't want to testify against me, she can invoke the privilege, but I cannot thrust it upon her. And again, that's federal. In Florida, that privilege doesn't even exist. Sally, you got to sing. Now, we do have the communications privilege, and that, yes, can be, anyone can invoke that. That's just really, we're not going to use private communications between lovers to incriminate them, because, or not to suggest liability upon them, because we want to honor the sanctity of marriage. And when you're in bed with your partner, you should be able to say things without feeling that the world will hear them. So the marital communications privilege is pretty robust. The spousal testimonial privilege is confined to only the spouse who's invoking it, and it is only a federal privilege. All right, let's try number 6. Which of the following is not a requirement for admissibility of scientific opinion under Florida evidence rules? Does anyone know what standard of evidence we use in Florida?
Dalbert.
Nice, Daubert. We went from Daubert to Fry, back to Daubert. When I was a law clerk for my uncle in 2013, that was like my big assignment. Switching from Daubert to Fry. Totally useless because we went right back. And I spent so much time on it. It was generated to all the lawyers in the firm. I expected at lunch that day to be like a hero. And then we read your letter. It was the greatest thing. Like, I swear, just went to people's email. They clicked next, like never even got read. Goes to show you, what's important in this world. Okay, anywho, number 6. Which of the following is not a requirement for admissibility of a scientific opinion under Florida evidence rules? The opinions based on scientific principles are generally accepted. The experts applied the principles to the facts of the case. The experts qualified to give the opinion. The opinion is consistent with the witness's prior statements. Okay. People are saying D here, right? Oh, someone says B. Okay, never mind. D, oops, yeah. Because B, these are all the three principles. And I do this on purpose. I do a lot of questions that say which one is not necessary. Why? So y'all can focus on the three that are necessary. Like, don't focus on this. This has nothing to do with it. But these are the three things necessary. Scientific principles generally accepted. They've applied the principles to the facts of the case, and they are qualified under Daubert, whatever, to give the opinion. Exactly. Scientific opinion's consistency with the witness's prior statement is not a requirement for its admissibility. While an inconsistent prior statement may be used to impeach the credibility of the expert, it's not a barrier to admissibility. So, Daubert, qualifying an expert witness, it has to be, they should be knowledgeable in the field, have specific knowledge, ideally publish some things about it. I keep telling my dad he should become an expert in appraising. But no one listens to me, in my family at least. All right, during a deposition upon oral examination, a party's counsel may instruct an opponent not to answer a question for which of the following reasons. The question asks for information that's protected by attorney-client privilege. The question seeks hearsay testimony that would be inadmissible at trial. The question asks for the opponent's personal opinion on a matter of fact. The question involves the opponent's personal feelings about the opposing party.
A.
Yeah, I like A, right? That's very important, attorney-client privilege. You shall recognize that in your pursuit of practice. That's a very important privilege. If you don't feel like you can honor that, you should do a different career, because that's the most important part of being an attorney, is your requirement to hold confidential communications between you and the client, because we want to foster a world where attorneys and clients can speak freely and there won't be any repercussions. So even in a grand jury proceeding where the rules of evidence do not apply, attorney-client privilege still is in effect. That's a very important privilege in the world. The question asks for information that's protected by the attorney-client privilege. During a deposition upon oral examination, a party's attorney may instruct an opponent not to answer a question if the question seeks information that's protected by a privilege. One common privilege that may be invoked is the attorney-client privilege, which preserves the confidentiality of communications between an attorney and their client. All right. During a civil trial, the plaintiff called a witness to testify. During the witness's deposition, they provide a statement that contradicts their current testimony in court. The defendant seeks to introduce the prior inconsistent statement to challenge the witness's credibility. Should the court allow the prior statement to be admitted into evidence? Yes, because any party can attack the credibility of a witness by introducing a prior inconsistent statement. Yes, because a prior inconsistent statement made during a deposition is always admissible for impeachment purposes. No, because a prior statement was not made during oath or during trial, was not made under oath during trial, or no, because a prior statement was not made in open court.
A.
I think it's A.
I think it's A too. And what's wrong with B? B is a little bit too absolute, or the opposite of absolute. It's too, it leaves too much room for interpretation. It's always admissible for impeachment purposes, not always admissible. There's reasons why we couldn't bring it in, but any party can attack the credibility of a witness by introducing a prior inconsistent statement. That is a true statement. This very, very similar to a Florida bar multiple choice question. People love to ask me that. What do the questions actually look like? Because some of the other companies' questions are outrageous. They don't actually look like them, but those questions are good to reinforce the laws you do need to know. So I've literally assigned some of them to you for those purposes, not to replicate what the questions look like, but to learn the law. This right here is a picture perfect Florida multiple choice question. It will look just like this, except it won't have every first letter of the word capitalized. But they're short, they're tough, and you have to really think through them. And another thing I will say, I didn't have this administration the ability to create questions like this on this platform, but there are questions on Florida multiple choice that are like, which of the following is true? 1, Andrew is funny. 2, Andrew is awesome. 3, Andrew is a loser. And then it'll be like, the answers will be like 1 and 2, 1, 2, and 3. 1 in 3, right? I teach for the securities exam, Series 7, Series 66. They're riddled with those types of questions. Those types of questions really suck, right? They're more difficult than a typical A, B, C, or D. You got 25% odds. Those questions now, they kind of make you have to eliminate some. And so it's tough. And that's another reason why I give you other questions to work from to replicate that manner of questions. So you're not shocked on test day when you do see questions like that. But they're very, so these questions that they look a lot like this, but the answer choices might be 1 and 2, 1, 2, and 3. I'd say that's a perfect synopsis of what the questions will look like. Exactly like this question right here, but maybe it'll have 1 and 2, 1, 2, and 3. That's how they kind of throw a wrench at you in Florida and make it a little bit more difficult, in my opinion. And to be clear, you're not tested on every subject in Florida multiple choice. You will be tested on procedure, civil and criminal procedure, and it also includes judiciary procedure. Now they're free to test you on evidence, which I think is very likely, and then business entities, which also includes secured transactions and commercial paper. Business entities mainly includes corporations and partnerships, but also now they're testing secured transactions and commercial paper as multiple choice. And then they could do wills and trusts. They're not very clear about their formula. I would guess they're going to definitely test criminal and civil procedure. Most likely you're going to test evidence, and then they'll either go one of two ways: trusts and wills, or business entities, commercial paper, and secured transactions. Again, they could test them all. They could only test 2 or 3. Like they have a lot of liberty, but that's what I would expect. Procedure, definitely, most likely evidence, and then one of the two. If I had to flip a coin and guess, I feel like wills and trusts over business entities, commercial paper, and secured transactions, but that's a coin flip. I have no idea. You do need to study for everything like it'll be tested. You're also lucky because when I took this test, we had more subjects. We had to do dependency. We had to do Karen, we had to do, commercial paper, secured transactions, essay subjects. It was a little bit more difficult. But anyway, let's continue on. So number 9, during a criminal trial, the defendant Mark is charged with assault against his spouse, Lisa. Lisa testifies that Mark admitted to physically assaulting her during an argument. Mark objects to this testimony, asserting the husband-wife privilege. How should the court rule on Mark's objection? Sustain the objection because the husband-wife privilege protects all confidential communications between spouses. Overrule the objection because the husband-wife privilege does not apply in cases involving crimes against a spouse. Sustain the objection unless Lisa unwillingly waives the husband-wife privilege. Overrule the objection as Mark's admission of assault is essential evidence in the case.
I think it's B.
Hey, Rosie, or Biscuit, whatever it means. I think it's B2. Anyone disagree or agree with B? My dog's gonna kill each other. All right, yeah, I don't think that if we have a case between the spouses, right? Or crimes against a spouse, then it would be fair to have this privilege because they're opponents. So overrule the objection as the husband-wife privilege does not apply in cases involving crimes against a spouse. In this scenario, the court should overrule Mark's objection to Lisa's testimony about his admission to assaulting her based on the husband-wife privilege. The husband-wife privilege typically protects confidential communications between spouses. However, an exception to the privilege exists when one spouse is accused of committing a crime against the other spouse. In this case, Mark is charged with assaulting Lisa, his spouse. As the crime involves violence against a spouse, the husband-wife privilege does not shield Mark from Lisa's testimony about his admission to the assault. Therefore, the court will overrule the objection, allowing Lisa's testimony regarding Mark's admission. Under Florida evidence rules, which of the following is not a requirement for admissibility of business records? So this is a good question to enforce what is necessary. The record was made at or near the time of the event it describes. The record was made by someone with knowledge of the event. The record was kept in the course of a regularly conducted business activity. The record was created for the purpose of being used as evidence in trial.
Yeah.
What'd you say? Anyone? It's not a
Me?
requirement. You said D?
Yeah, this
D as in dog.
D as in dog. That's what you said, Dad? Dad says D as in dog. Let's see. Old man on the couch. Oh man, look at you from the sideline. Good work. The record was created for the purpose of being used as evidence in trial. Under Florida evidence rules, the admissibility of business records is governed by the hearsay exception known as the business records exception. To be admissible, business records must meet certain requirements, but being specifically created for use as evidence in trial is not one of them, right? That's if it's created in anticipation of litigation, then it's not going to be admissible. That's going to be protected. So what is a requirement? It was made at or near the time of the event it describes. It was made by someone with knowledge of the event, and it was kept in the course of a regularly conducted business activity. Those are the requirements that ensure that the business record is made in a timely manner by someone with firsthand knowledge or reliable information about the event and in the normal course of the business operation. Oh, that's cool. You can't even copy my stuff. I like that. You know, I wrote these questions myself. Been working down there in Miami. All right. During a civil trial. Yeah, you're right.
Yeah.
All right. You're still on the hook. You're still on the hook. Listen, during a civil trial, the plaintiff's attorney asked the defendant if they made a settlement offer to the plaintiff prior to the trial. The defendant's attorney objects to the question. How should the court rule on the objection? Overrule the objection as settlement offers are admissible as evidence of liability. Sustain the objection as settlement offers are generally inadmissible under the Florida rules of evidence. Overrule the objection as settlement offers are relevant to the credibility of the defendant. Sustain the objection as settlement offers are only admissible if they are in writing.
I mean, B, but.
B, it is. Yeah, there we go. Let's go. Man, I agree with B. Anyone disagree with B?
I'm not paying that much attention, but B.
He said not paying that much attention. Anyone disagree or think that B is incorrect? I want to go against the old man. 2 for 2. Under the Florida rules of evidence, settlement offers are generally inadmissible as evidence in civil trials. The purpose behind the rule is to encourage parties to engage in settlement negotiations without fear that their offers or discussions will be used against them in court. All right, 2 for 2. Here we go. Which of the following is not a requirement for admissibility of a dying declaration under Florida evidence rules? The declarant must have believed death was imminent. The statement must concern the cause or circumstances of the declarant's impending death. The statement must have been made to a medical professional or law enforcement officer. The witness is now unavailable.
See,
Yeah, it's an easy one, you know, a little toss-up. You gotta give the people some toss-ups. But the reason I like these questions is because it tells you the things that are necessary for a dying declaration. They must have believed the death was imminent. It can't be like, you know, we're all gonna meet our maker one day, so you can't just say things and be like, yeah, I knew it. No, it has to be like, oh no, you know, the time is now. Again, it must concern the cause or circumstance of the impending death. This is a big one. It can't be like I'm about to die and I say, and the trust should go to Tommy, you know, like it can't be like something totally unrelated to the circumstances of your death. It has to be like he stabbed me, or like, hey, your dog has a boot in its mouth. Yeah. All right, whatever. The statement must have been made to a medical professional, law, totally irrelevant, and the witness is now unavailable, right? Just like statement against interest, dying declaration is one of those hearsay exceptions where unavailability is required. When we talked about unavailability, they don't have to actually die. They could be in a coma. They could be out of the country. They could be somewhere else, but they can't be here. It's like closing time. You can go anywhere but here. Under Florida evidence rules, which of the following is not a requirement for admissibility of a statement against interest? The statement must have been made by a person who's unavailable as a witness. That I think I just talked about. The statement must be against the declarant's proprietary, pecuniary, or penal interest. The statement must be corroborated by other evidence. The statement must have been made voluntarily and with a consciousness of its implications.
I think it's C.
Yeah,
I don't think it needs to be corroborated.
I don't think it needs to be corroborated either. Let's go with C. The statement against interest to hearsay does not require that the statement be corroborated by other evidence. I was like, you guys might be in for a problem because I don't know if I have the right charger, but I can't. Which of the following is not an exception to the best evidence rule under Florida evidence rules? The original is lost or destroyed, the original is in the possession of an adverse party, the original is a public record, or the original is a trade secret. So three of these are exceptions to the best evidence rule. The best evidence rule states, when the evidence is at dispute, like a letter or a painting, we need to actually bring in the original. But there are some exceptions. What are these exceptions, and which one of these is not an exception?
Yeah, trade secrets.
Yeah, it doesn't need to be a trade secret. It definitely needs to be the first three pieces. The best evidence rule requires that the original document be produced unless it's been lost, destroyed, or is in the possession of an adverse party. The fact that the document contains a trade secret is not an exception. Okay. During a criminal trial, the prosecution calls a witness who testifies the defendant, John, told them, "I committed the crime and I'm guilty." John's defense attorney objects, arguing the witness's testimony is inadmissible hearsay. The prosecution argues that the statement should be admitted as an admission by a party opponent. How should the court rule on the objection? The court should sustain the objection because the witness's testimony is hearsay. The court should overrule the objection because the witness's testimony falls under the exception for admissions by a party opponent. The court should abstain the objection because the witness's testimony is not relevant to the case. The court should overrule the objection because the witness's testimony is a statement against interest.
B.
You said it's B, it's a party opponent admission. Anyone disagree? It's a party opponent admission because they're a party, the defendant, and he said, "I committed a crime and I'm guilty." I mean, the writer, let's see if it's B before I start laughing. But yeah, the writer of this made it pretty obvious this was an admission. On the test, it might be a little more subtle. It might be, "I'm sorry for the inconvenience we caused," something more subtle. I wouldn't be like, "Yeah, I'm guilty." I'm trying to teach concepts here. The court should overrule the objection because the witness's testimony falls under the exception for admissions by a party opponent. In this scenario, the prosecution seeks to introduce the witness's testimony regarding the defendant John's statement, "I committed the crime and I'm guilty." John's defense attorney objects, arguing that the testimony is inadmissible hearsay. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. However, there are exceptions to the hearsay rule, and one such exception is admissions by a party opponent. Admissions made by a party to the litigation are generally admissible as evidence against them. All right, I have a really fun day planned. It's going to be multiple activities. So we'll do 2 or 3 more of these questions. I'll stop the recording, interactive activity, and then another recording. So be prepared. Under Florida evidence rules, which of the following is not a requirement for admissibility of a prior inconsistent statement? The declarant must be subject to cross-examination at trial. The statement must be inconsistent with the declarant's trial testimony. The statement must have been made under oath at trial, hearing, or deposition. The statement must be offered to impeach the declarant's credibility. What's the chat say? We got
I think it's C.
C's.
Yeah.
I think it's C too. Doesn't need to be made under oath, trial, deposition, right? Prior inconsistent statement. Tommy is up here saying the light was red, but we have a statement of him saying earlier that it was yellow. We're gonna bring it in to impeach, but he didn't say it at trial. He just said it. Tough question. The statement does not necessarily have to be made under oath at trial, hearing, or deposition. Prior inconsistent statements are made outside of a courtroom setting, such as casual conversations or statements to friends or family, can still be admissible if they meet other requirements, right? Like I just gave an example, the red light, yellow light. Which of the following is not a requirement for admissibility of evidence of habit under Florida evidence rules? The evidence must be specific and consistent. The habit must have occurred on a sufficient number of occasions. The habit must have been developed within the past year. The habit must be relevant to the issue at trial.
Yeah.
I mean, one of them is definitely unrealistic, untrue. It doesn't have to be developed in the past year, right? I know people who've been smoking cigarettes since the 90s, right? Like the requirement that the habit must have been developed in the past year is not a specific requirement under Florida evidence rules. The time frame within which the habit was developed is not explicitly mentioned as a criterion for admissibility. Under the Florida evidence rules, which of the following is not a requirement for admissibility of recorded recollection? A key thing, you know, Amy taught this in class. Difference between a recorded recollection and refreshing someone's recollection on the stand. A recorded recollection is a statement that's made out of court that was recorded, that was accurate at the time it was made, that they no longer have memory of. Whereas a refreshing recollection on the stand can be anything. You could literally give the person a piece of paper that says exactly what they're supposed to say. They read it and then they say it. It could be a bowl of spaghetti, right? It could be anything, but those are different concepts. You could pretty much refresh someone's recollection with anything. If you're actually going to admit evidence of a recorded recollection, it has to meet those requirements that I just stated. So what's the answer to this one? The witness once had personal knowledge of the matter. The witness now has insufficient recollection to testify fully. The record was made by the witness when the matter was fresh in their memory, or the record was made in the regular course of business. Anyone? Yeah, it's got to be D. D has nothing to do with that. Well, B is the business record exception. It's not the recorded recollection. All right, we'll do two more and then we'll move to the activity. During a trial for financial fraud, the prosecution calls a witness who is the defendant's accountant. The prosecution intends to question the accountant about financial advice provided to the defendant. The defense objects to the testimony on the basis of privilege. How should the court rule in the objection? The court should abstain the objection based on the attorney-client privilege. The court should sustain the objection based on spousal privilege. The court should overrule the objection because there's no applicable privilege. The court should sustain the objection based on the accountant-client privilege. Yeah, the answer to this one is D. And I asked Matt, my genius friend, if that is recognized in federal law, and he said he did not believe so. So until I hear otherwise, I don't believe that that's a federal privilege, but is a specifically recognized Florida privilege, the accountant-client privilege. Although I'm sure at federal law, there's some laws about that, you know. Accountants, I feel like accountants know even more than lawyers. The court should sustain the objection based on accountant-client privilege. The privilege ensures that clients can freely communicate with their accountants and seek advice without fear of their confidential information being disclosed in court. All right, one last question for the first recording of this class. Under Florida evidence rules, which of the following statements regarding impeachment with criminal convictions is true? The privilege against self-incrimination applies to past convictions and prevents their use for impeachment purposes. Only felony convictions are admissible for impeachment purposes. A witness's credibility is irrelevant when considering the admissibility of past convictions for impeachment. Impeachment with criminal convictions is permissible on cross-exam under Florida evidence rules.
I disagree with everything except D.
Okay. Disagreeing with everything except D is another way of saying that D is true. Perfect. So the provided statement explains that Florida follows the view of the federal rules regarding impeachment of criminal convictions. In Florida, as in the federal rules, a conviction for a felony, punishable by imprisonment of excess of a year, or a misdemeanor involving dishonesty or false statement can be used for impeachment purposes. Perjury, being a crime involving dishonesty, can be raised for impeachment purposes on cross-examination. Okay. And awesome. Suzanne just told us that there is no federal accountant-client privilege. So as always, Matt Beckerman was indeed correct. So that was the first part of class. And as you know, that's your assignment is to finish those questions. You can see, I think those questions are very helpful. I would do them religiously and get 50 out of 50 before test day. So thank you all so much for joining me for the first part of class. I'm going to go ahead and stop this recording.